Spencer Dickson, welcome to Landlord Confidential.
Thanks so much for having me.
Absolutely. Let me introduce you to the audience real quick. So you're a son, you're a husband, you're a father, you're an Iron Man, and an attorney. What did I miss?
Aspiring pickleballer.
Interesting.
Love racket sports, grew up playing ping pong. Good to transition to the court.
Awesome. You out there every day, or how often are you getting after?
Try to get it once a week or so, get a little game in.
You getting any good?
Trying to work my way up.
Yeah. Pickleball versus tennis. What's that rivalry all about?
You know, tennis players are just kind of are full of themselves a little bit, you know? They don't like that the masses are now appreciating a racket sport. That's what's going on.
I go on walks with my son every morning, and at the court, there's tennis courts there. There's big signs like no pickleball allowed here. So clearly they're getting invaded by the pickleballers, and they're not happy about it.
No, and I love it. My wife played tennis in high school. I love playing tennis, but let everybody play. Let's share the
one
love.
a little bit easier than the other, like less fitness required.
Sure. I think pickleball's easier for the mass audiences.
Yeah,
you know,
makes sense.
Yeah. Let's start with, where did you grow up?
Yeah, I was born and raised in McLean, Virginia. So Northern Virginia, inside the Beltway, D.C. area. The story we like to tell is that one day on our way home from a Sunday dinner, my grandma took a wrong turn and turned into the CIA headquarters.
Okay.
So she blew past a checkpoint, went a little farther than she should have, and had some folks, she says, coming out of the woods with guns drawn, saying, "Please, ma'am, why don't you turn back around?"
Really?
So we were, it's cool to grow up in the D.C. area, kind of right there, right in kind of the thick of things.
In the swamp.
Yeah,
Swamp.
exactly.
So you went from the humid swamp out here to Arizona. What brought you out to the desert?
To the dry heat. I went to school in Utah, met a girl from Mesa. She brought me to Mesa in February 1st, so she kind of put Arizona's best foot forward.
Smart move.
Yeah, exactly. And we ended up choosing ASU for law school, and so we kind of stuck here.
Awesome. So you already accepted and enrolled before the summer hit, and you couldn't turn back anymore.
There was no backing down. Exactly right.
Amazing. And then, so you went into law school, and how soon did you know you were going to go into landlord tenant law?
You know, I started working with a partner of mine that's actually my wife's father, and that's the area of law that he practiced. He represented landlords in residential eviction actions and other type actions. Started working with him right out of law school, and it just stuck.
And what was it that appealed to you?
You know, I like, just in general about the law, I like advocating on behalf of other people. I like giving people advice. I'm attracted to the idea of helping people.
And do you typically just represent landlords? Are you representing residents as well?
You know, in a past life with my other firm, I did represent tenants from time to time. It'd be in very specific cases where I could tell immediately that a landlord had broken the rules, wasn't following the law, and I knew that I could help a tenant out in certain circumstances. Now that I'm at this new firm, we exclusively represent landlords, so not anymore.
We were super excited when we saw the news that you joined Zona Law. They've got a great reputation around the valley. What prompted you to make that decision?
Yeah, you know, kind of in the olden days, pre-COVID, we'd be sitting in court waiting for hearings to start, and you've got all these lawyers lined up, each with their stack of cases, and you eventually kind of start to think, hey, if you just hand me your cases or I hand you mine, one of the two of us doesn't need to be here, right? Let's collaborate, let's work together. And so then even after COVID, I've been working with Scott Williams, Mark Zinman, and many of those attorneys in collaborating, in doing court coverage with them, in working together on different projects. We just, conversation started where we said, hey, what happens if we work together? What if we merge our firms? Is there a benefit to, sharing some overhead, in sharing some experiences and things like that? So we made a deal. I brought some staff over with me. It kept largely doing what I've been doing before. So it's been a smooth transition.
Yeah. A couple months in, we're really happy with the transition. How's it going for you?
I feel great about it.
Yeah.
I feel great about it.
Is the time savings coming in? You have extra time to spend with the family now, or?
Sure. And the thing that's great is, of course, ask my wife, but I was able to get on vacations, kind of working on my own essentially, but we'd have road trips where I'd have a stack of files in the car. I'd be calling court, on the drive to California. There were just different things where sort of a really cool thing about working with a larger firm is there is that ability to say, hey, I'm going to sign out, I'm going to check out, and can you guys have my back while I'm gone?
Mm-hmm.
And vice versa, right? I can help out while folks are out. So
I'm sure the
It's been
family
great.
really appreciates that. You can unplug, enjoy
Hey.
your time, and not have to be checking in on email and phone calls.
absolutely. And I would just also want to point out that it's just really cool to be able to walk down the hall and be able to, collaborate with other attorneys, bounce questions off each other. There's that camaraderie and just a bunch of great people at that firm.
Yeah, it's
Nice.
amazing being able to lean on each other's experience, get feedback. Like you feel mostly sure, but you're in law. Like you want to be 100% sure, right?
For sure. And I mean, that's the crazy thing about the law, right? I think that I can have a good idea, but reasonable people can disagree, right? And some other lawyer may have some other experience or some other perspective, and we can get the right answer.
So what are you spending most of your time doing? What kind of cases are you?
Yeah. Kind of the bread and butter case is a residential eviction case, right? And so, you show up to work and there's going to be a calendar of what courts are you covering that day. And you're going to expect that you're going to be doing court appearances representing landlords in eviction actions in the various courts. One of the cool things that happened, one of the few benefits of COVID is that we've kind of transitioned to almost all of the court appearances in the first instance are virtual. So instead of driving to Apache Junction and down to Phoenix and to Gilbert, you can do a lot of what you do just virtually, remotely.
Wow,
So
that's a
you
huge
can,
time savings.
you can pop into a court. Sometimes when a case gets set for trial, or sometimes when there's some reason for it, you got to go in person. But for the most part, you can just handle all your courts, handle initial appearances and eviction actions from the comfort of your desk. So that's what an ordinary day looks like doing residential eviction actions. On top of that, you'll have some tenant disputes, right? Tenant sues a landlord over a security deposit issue, something like that, and I'm working on the defense of that case. Somebody files a fair housing complaint. I'm working on the defense of that fair housing complaint with the governmental agency.
Mm-hmm. Let's start with the most basic one, the standard eviction. Like, what does that process look like from start to finish?
And it looks like slightly different depending on different clients may handle that process a little differently, right? Many clients take it upon themselves to issue a 5-day notice. Every eviction action starts with a notice that tells the tenant what they're doing wrong, whether it's non-payment of rent, whether it's, hey, you're causing too much noise, you're fighting with your neighbor, whatever it is. We start with a notice, okay? And then once the time period for the tenant to comply with that notice expires, usually the file comes to my office.
Mm-hmm.
We've got some excellent staff that take those files. They prepare the documents. I review all the documents, but they're going to say, hey, was this notice served properly? Does it contain all the contents that are required under the law? We'll get that thing filed. Usually we can get a court date within about a week. So we're in front of a judge, having a tenant appear in front of the judge and either say, yes, I'm guilty of not paying the rent, or no, something else is going on. The landlord's not doing this or that, or something else is happening where I'm not required to pay rent for whatever reason. Once it goes to that stage, most of the time we end up with a judgment. We end up saying, hey, this tenant has been found guilty of forcible detainer, and you can get what's called a writ of restitution, and that's the order that commands the constable to come out to the property and actually remove the tenant. So from the notice, about 5 to 10 days pass before we can actually file the thing. About another week passes before we get in court, and about another week before we can actually have the tenant removed. So, depending on what type of notice and what type of case, you're talking about 3 to 4 weeks before we can actually have a tenant out.
Yeah. So at the time of the judgment, the judge will give the tenant a date that they need to vacate by, right?
That's right.
And if they don't, then you can go back and order a writ of restitution where the constable will come and meet you there.
That's exactly right.
So
they'll know when the date that court happens. They'll know that writ date, the date by which they need to vacate.
yeah, okay,
Yeah.
Interesting.
So if they haven't vacated, it's up to the property manager or the landlord to verify if they're still in the home and then request that writ if they are still there, right?
Yes, and that's a question. Sometimes that's just a communication issue between my firm and clients. We just want to make sure that clients know the best way to reach us. We've got a few different avenues for reaching us. One is a client portal that you can use, or just shoot an email. But we do rely on clients to tell us whether or not the tenant left. I mean,
Sure.
it's not every eviction case that we need to file a writ.
Yep.
Sometimes the day of court, tenant shows up and wants to pay everything, and sometimes the landlord wants to accept it. So you go, great. The two sides are going to exchange some money. Tenant's going to remain there. There's no other work for me to do. So we don't need to order a writ in that case. Sometimes the tenant realizes they better pack up and leave, and they do. So we just leave it where we're just waiting for clients to let us know if and when they need a writ. we'll make sure the appropriate time has passed and we'll get it filed.
And you mentioned like the funds at that time. So if a tenant shows up to court and they're ready to pay in full, is the landlord obligated to accept the funds at that time?
Yeah, so every complaint in Arizona, every eviction action needs to contain language pursuant to the rules that says, if this is a non-payment of rent case, and if the tenant shows up with everything that's demanded, and that includes all past due rent, if we're newly into the new month, that includes the next month's rent, right? Late fees, court costs, attorney's fees. If the tenant pays all of that, essentially tenders a payment in full, then the landlord has to take that amount.
They do have to take
They do have to take that amount. And again, it's a full payment, right? If we're suing for non-payment of rent and the tenant has all the rent, we've got to take it. Arizona is what's called a cure state for that reason. Of course, there are some nuances there. If you're filing an eviction action for any other reason, like a non-compliance issue, then no, you don't have to take the rent. And if there are other issues, then let's talk about them specifically. Once a judgment's entered, though, right? Contrast that with after a judgment, right? You get a judgment. The judge says, tenant, you owe $3,000, and you have to be out by, March 13th. The tenant might show up then to the office and say, okay, I've got the full $3,000. Can we make a deal? It's up to the landlord through his property management company to decide. Are we accepting the money and we're continuing the lease? Yeah. Or, you know what, hey, we're done working with you. I'm sorry.
Yep.
Can the landlord even accept the money and continue with the eviction at that point?
There are a few, we would recommend that you fill out what's called a post-judgment non-waiver agreement that says exactly that, right? The thing that we don't want is a disagreement about what the acceptance of the money means, right? I don't want a tenant to show up, pay the $3,000, and then be surprised when the constable shows up to kick him out saying, the landlord agreed with me that if I paid them some money, then I got to stay, right? I'm paying the money with the intent to stay, and the landlord tricked me. That we have cases like that. They end up filing a motion to vacate the judgment or set it aside. So the answer is yes, you can accept the money and still proceed with an eviction. The safest thing to do is to just put that in black and white. We're taking the money. The money is just in payment of this judgment. We'll file a satisfaction of judgment after the fact, but we're not reestablishing the tenancy. If you put it in black and white, it's simple. Everybody understands the deal.
Mm-hmm.
And
that makes sense.
You go forward that way.
Have it in writing at that point.
You got
no
it.
disputes.
You got it. Yeah.
Let's say you're going to enforce the writ and you show up there with the constable and the tenant is still residing in the home with all of their possessions. What are the landlord's responsibilities there?
Yeah. So the difficult thing for the tenant is the constable's going to give them just a few minutes to gather what they need, right? Essentials. We're talking medications, maybe important papers. The constable's usually not going to wait for a moving truck to show up and have them remove their items. So landlord is going to be stuck with a situation where they have a tenant that's been removed and they have these tenant possessions, right? And there's a section of the statute that deals with dealing with tenant possessions. I get this call all the time from landlords. I've got an information sheet that I provide. We can go through some of the lists, but the key is use reasonable care in moving and storing the items. A landlord at its option landlord could pack up all that stuff. If they have a tenant that they want to get in there, landlord could pack that up, move it to a storage unit, give the tenant notice of where it is and how to retrieve it. The tenant's responsible for paying the moving and storing costs, if that's the case. There are certain obligations about you don't need to keep any food or perishable items. Mm-hmm. If there are animals there, you can take them to a shelter. You can just use reasonable care in moving and storing these items. But the tenant has certain timelines. The tenant has 14 days to come and attempt to retrieve the item. So no, you can't just toss the stuff once the constable changes the locks, but you've got some obligations.
And if that 14-day window expires and they haven't done anything, all their items are still in the home, then what?
The statute says that you can conduct a sale of the items, but that's fairly complicated. You need to post some notice. There's a procedure for doing that. At that point, yes, you can dispose of the items.
What should a landlord do if they receive a bankruptcy notice in the middle of an eviction?
Yeah, you should call me is the answer. A bankruptcy has some rights that are baked into it, right? And the primary one is called the automatic stay. Stay meaning pause, right? It puts a pause on collection activity. It puts a pause on any kind of civil action that we've got going. So it essentially puts the brakes on our eviction action. The cure for that, what we need to do is we would help you get in touch with a bankruptcy attorney that's going to say, Dear Mr. Judge that's in charge of the bankruptcy, we'd like to move forward with this eviction action. This is about non-payment of rent. We're not really involved in the bankruptcy. Sure, the tenant might be dealing with creditors, credit cards and things like that, but we'd like to move forward with our eviction. And so we need to take this little, mother may I step first, going in front of the judge to say, can we please move forward with our eviction action? That's called a motion to lift stay. And you do that through a filing in the bankruptcy court. So, and sorry, just to add there, then the practical advice is, please don't issue any more notices. Cease your collection efforts, right there, because you run the risk of violating that automatic stay, which contains some penalties.
Makes sense. So bankruptcy can interrupt the process. You said most of the time these evictions are going through, the landlord's winning these. What are some other instances that might cause the landlord to lose the case or delay the case?
Yeah. The best way to lose an eviction case is to accept a partial payment while the eviction is pending.
Which is anything, right? Like you collect $1 and you've collected a partial payment.
Sure. And so you want to train, if just depending on how you set up shop, right? If you're a landlord or property management company that has a front desk where tenants are dropping off payments, you want to make sure that you're training staff that if we're contemplating receiving a payment, let's see, are we in eviction status? What is the total amount that's due? Is this a partial payment? Is it a full payment? If you're set up to process payments online, right? Sometimes we got landlords that have tenants just making direct deposits into their bank. And the tenant says, hey, I paid. And the landlord says, really? Did you? I need to check. I need to confirm. There are ways of dealing with that. Sometimes you do have tenants that make cute payments of, hey, I'll pay you $25 before court. That's a partial payment. And that's my way to get out of jail. There are ways to reject that partial payment. So you can deal with that. But so, and then I just also want to point out, and again, this is my sales pitch, I guess. The best way to avoid some of those issues is to use a law firm to process your residential eviction, because everything is going to be screened at the beginning. Did you give the right notice? Did we wait the appropriate time? Let me look at your lease and your ledger. I mean, I have cases that come across my desk all the time where you have the tenant, we're going to evict a tenant, but hey, they made a payment on March 2nd. So did you know about that? And so I'm picking up the phone before court ever happens, before you ever incur the cost of filing, going, hey, look, maybe let's issue a new notice. Let's circle back. Let's do this next month, or let's reject that partial payment and we can proceed anyway. So, so the answer is landlords don't typically lose in eviction cases because of that pre-screening, because of the nature of the cases. Right? Did you pay rent? Right. No, you didn't pay rent. Sorry.
Pretty straightforward.
Yeah.
So trust the experts. You obviously go through this process continually versus a landlord trying to figure it out on their own. Hire a professional who knows it.
Sure.
Been through it a million times. And of course, we get this question all the time. Landlords think the first thing they worry about is an eviction in Arizona. They're too concerned about this. Like, how much does it cost? How long is it going to take? Luckily, like you just explained, Arizona is an extremely landlord-friendly state. So if your resident's not paying, you're going to have them out typically by the end of that month and at a reasonable rate. Like, it's not an expensive service to hire your firm to handle an eviction.
I think it's a good due diligence way of handling eviction actions. Yeah, it's not, I would encourage people to just, give us a call and let's talk rates. And it's not going to be something where you think, oh, I'm hiring a lawyer, I'm going to spend thousands of dollars to do an eviction.
Yeah.
No,
Absolutely not.
Do you see a lot of landlords doing their own evictions?
So you see it sometimes. And I just kind of get nervous. And I go, hey, great, I'm a cheerleader there. I'm okay if somebody wants to try to file an eviction action on their own.
Yeah.
And like we said, the laws, I think, are generally favorable to landlords, but there are some technicalities, right? You need to give a 5-day notice that contains this language in it. And oops, you didn't do that, you wrote your own, a judge might throw your case out. And you'll start over and do it again, but you could have saved yourself a lot of time and a lot of hassle by just going through a professional.
Right.
Sure. Yeah, so, and the only other, just also want to point out, sometimes even the requirements for giving a notice, I think the statute is somewhat outdated, right? The statute says either hand delivery, which means handing a piece of paper to a tenant, or via certified mail. I mean, nowadays there are plenty of other ways that we communicate with each other, but a landlord saying, sure, I took care of it. Yeah, I emailed the notice to the tenant. A judge might find that that's not sufficient service and bounce the case for that reason.
That makes sense. What about rental assistance? Like, there wasn't too long ago where a lot of rental assistance funds were floating around, and I think that was causing some delays in the courts. Is that still happening?
Sure. COVID-19 threw a wrench in everybody's lives in plenty of different ways. It changed the way we process eviction actions in a few different ways. It was always interesting or crazy or nerve-wracking to. Sometimes you come to work the next day and you read in the newspaper, hey, the laws are totally different now.
Yeah.
There's a new executive order now. Governor Ducey signed a new executive order. Congress put a stay. The CDC put a stay on eviction actions, a moratorium. To a large extent, all of those protections have somewhat evaporated, right? The automatic stay, the moratorium on eviction actions has expired. There are not any executive orders right now that cause us to not be able to file eviction actions for non-payment of rent. And I say that with probably just about one exception, and that's that the CARES Act still exists. The CARES Act was passed in 2020 and provided for certain delays in processing of eviction actions and gave different timelines. And another reason that, hey, best to use an attorney here, the CARES Act says that instead of giving a 5-day notice in certain circumstances, you need to give a 30-day notice. You need to give a 30-day notice if your property is backed by is financed by a federally backed mortgage. Mm-hmm. So that's a complication that still exists. That is still the primary thing we need to check with landlords about. Hey, here's a COVID-related issue. Is your property subject to the CARES Act?
Yeah.
Right?
So there are no obligations for a landlord to seek rental assistance on the behalf of their tenants?
Right. That's right. The short answer is that you're absolutely right. Often that's the main thing that a tenant says in an eviction case, even through today, right? I'm working with a rental assistance agency. I've been approved. The landlord knows the money's coming. I feel great about that. I want tenants in need to get the assistance that they need. But the fact that they're working with a rental assistance agency, the fact that they even if the funds are available, the landlord's not obligated to accept those. Landlord might choose to accept those. It might be a win-win, might be the right answer, might be something that they'd like to do, but they're not required to accept those funds, and it doesn't slow the process down.
Go ahead.
We've been talking about evictions for non-payment of rent. What other sorts of evictions do you see?
Sure. Probably the second, we'll say probably the second most common type of eviction is just a non-renewal of the lease. Landlord is ready to rent somebody else, ready to sell, ready to do something else, and hey, we've come to the termination of the lease. We had a month-to-month lease, what have you, and we gave a notice that the lease is ending. Laws differ in different states. In some states, that 30-day right to terminate a month-to-month lease doesn't exist. You need to have good cause. Mm-hmm. And so some tenants take the position, no, you can't kick me out, right? Mm-hmm. I'm going to stay. Yes, you gave me a notice to vacate. Yeah. I'm going to stay. I'm going to see what happens. And in Arizona, although there are a few exceptions, for the most part, the landlord has the right to terminate a month-to-month lease by giving 30 days notice. And so when tenants fail to vacate, we bring an eviction action for that reason. Mm-hmm. There are different penalties that kick in, but we can still process the eviction action that way.
Yeah, is that called a holdover tenancy?
Sure. We'd call that a holdover. The tenant is a holdover tenant. We'd call it a residential non-renewal. Put it under a few different names. But yes, somebody who stays over beyond the termination of the lease is holding over. Yeah.
And does the timeline of that process look similar?
The eviction process looks the same. Timeline looks the same. You would still want to give the notice, and maybe that's the difference. You need to give notice 30 days prior to the end of the lease, right? Or 30 days prior to a rental renewal date. So that timeline is different. But once it comes to my office, once we're filing, getting a court date, getting a writ date, that move-out date, those timelines look the same.
So pretty standard timelines with most of these evictions. Would there be any situations where there's grounds for an immediate eviction?
Sure. An immediate eviction is one where the tenant has committed a material and irreparable breach of the lease, right? So we're talking about discharging a firearm. We're talking about drugs, crime, prostitution.
Generally breaking the law in this case.
We're talking about crime that's happening inside the property, use of drugs, manufacture of drugs. It can also be, we can also be talking about fights, right? If a tenant comes in and is threatening or intimidating another resident or is threatening or intimidating management, then that can be grounds for giving a notice of immediate termination. So those have a shorter timeline. The notice We issue a notice, we get into court, you can get a writ of restitution the next day, right? And so there's a little bit of a heightened standard. We'll give you advice on what we need to do. We'll give you advice on whether that's an issue that, yes, we should seek an immediate on that issue because this person came in and was threatening. Or we might tell you, you know what, why don't you give the tenant a notice of noncompliance? This wasn't maybe this is somebody who just, had words with somebody else and may not be threatening or intimidating, but you know what, we don't want you coming into the office and raising your voice. And so here's a notice of noncompliance.
So more subjectivity involved there. That's
Sure.
more of a he said, she said dispute
Sure.
in court that the judge is going to hear on.
Exactly. And it's one that we're going to, typically we tell our clients that on a non-payment of rent case, you're welcome to join the proceedings virtually, right? We'll send you a link. You can jump into the virtual courtroom and watch court happen. But we generally don't need any testimony in a non-payment of rent case. We'll set forth, here's the ledger, here's the lease, here's everything. We don't, the landlord doesn't have much that they're going to need to say. Contrast that with an immediate eviction. I need a person that's going to testify. Hey, here's what I saw. Here's when the police showed up. Here's what the tenant did.
So typically that'll help. Like you would probably want a police report if you're going to go into an immediate eviction.
If we're talking about an immediate eviction, we need to prove that the tenant committed this act of a material and irreparable breach. So what happened, right? So yes, a police report, eyewitness statements, or eyewitness testimony, right? We'll get, we're having a little mini trial right then and there in the court about what happened.
Makes sense. What about squatters? Like sometimes you end up with tenants who you never wanted in the first place. They just end up in your home during a vacancy. Do they have rights? Squatters have rights?
Sure. Now the funny thing is, if you have someone that doesn't belong there, you can. Landlords ask me this all the time. Can I call the police? You can. If the police find out that there's some drug activity going on, if maybe there's a warrant out for their arrest, maybe something's going on, maybe there's evidence that they broke in, right? There's the glass and they admit it or something. The police might arrest them and remove them. There's a possibility. No real harm in doing that. If they say, no, I live here because I've lived here for a couple months, and or if they say, hey, here's my lease, and they hold up a piece of paper that they say is their lease, the police might say, this is a civil issue and I'm not going to do anything, right? No evidence that they committed a crime. They're not going to do anything. And so we say, do they have rights? Sure, the landlord is forced to go through the residential eviction process. So the landlord should give them a notice that they're not authorized to be there. It's not a non-payment of rent notice. It's just a notice that I'm demanding that you vacate this property. And then you go through the same process. File the complaint, get a court date. Sometimes we don't even know their names. We're finding cases, John and Jane Doe. And the judge is saying, anybody live at 123 Main Street? Anybody? And sometimes people say, yes, I am.
And you should actually put that on the notice, right? John and Jane Doe, when you notice them,
John and Jane Doe, any and all occupants,
Domestic violence victims in Arizona, what are their rights, and how should landlords respond when they get an alert that there was a domestic violence situation?
Sure. So the law tries to protect domestic violence victims, and I think we all should, right? We want to be sure that we're not re-victimizing somebody who's been the victim of domestic violence. The law says that under certain circumstances, a victim of domestic violence can show you either an order of protection or a police report that says that they were a victim. The statute spells out certain types of relationships, right? It's boyfriend and girlfriend, or like a sexual partner, or someone that lives with, or a roommate, right? It only applies in certain circumstances, right? If someone is assaulted at their workplace, or someone is assaulted, in the park, this statute doesn't necessarily apply to them. And I don't know why we make the distinction, but the law does, right? So it's domestic violence in the home. And if they're the victim, they can show certain documents and they can say, hey, I would like the lease to terminate within the next 30 days. And you guys can work on a lease termination. That victim is released from the lease without penalty. The perpetrator of domestic violence is then responsible for any damages that you have as a result, right? For breaking the lease, for that month's rent, whatever it is. The aggressor is on the hook for any damages that the landlord suffers there. So, I think that the good advice is we don't want to, the victim is required to go through this process, right? If the victim just says, sometimes we have these heartbreaking situations where a tenant doesn't pay rent, and then the tenant says, well, I didn't pay rent, but I was the victim of domestic violence 6 months ago. And you say, the landlord could make a choice, I suppose, could say, fine, I don't want to evict this person, but the law says that she didn't meet the requirements of the statute, right? The domestic violence had to have happened within the past 30 days. She has to provide the order of protection with the police report. So, I mean, we can all use our own humanity and our own, common sense and professionalism in making those choices. But I'll just help you with the legal side and spell out what are the requirements, when does it apply, when does it not apply, when is somebody able to terminate the lease.
Mm-hmm.
And do you ever see any situations where landlords are trying to not deny that right and the tenants are having to go through courts in order to get out of their lease?
I've seen it, but typically, I mean, I'd like to say, and I can say that I represent folks who, if they acknowledge that, hey, this person was the victim, this person complied with the statute, sure, we're going to comply with the statute too. And that's the smart answer, that's the human answer. And most of the time what happens is the landlord wasn't aware, right? Manager doesn't know because the victim didn't come forward, the victim didn't say anything. And so hopefully they're still within that window to say, hey, look, this is what's happening, please let me out of the lease.
Yeah. Are there any differences in the eviction process for a Section 8 tenant?
There are different requirements in terms of what we need to put into our summons and complaint, right? And a Section 8 tenant is someone who's receiving a subsidy from the government, right? Either a voucher or so. Government is paying a portion of the rent, and the tenant is paying a portion of the rent. There are laws that say that we mentioned partial payments. The government's payment of their portion of the rent does not constitute a partial payment. Mm-hmm. So we can bring an eviction action over, tenant, your obligation was to just pay this $100 a month in rent. You haven't done that, so here's your notice of non-payment of rent. Yeah. And again, on our end, yes, we have different requirements in terms of spelling out, here was the government obligation, here was the tenant's obligation, here's the total amount that the tenant owes in terms of the tenant portion. But again, the timelines look the same. Section 8, though, has a few other, we'll call them landmines, cautions to look at, to take care of. You want to make sure that you're terminating those leases with a different requirement. There are different timelines to do those. And usually and you want to make sure that you're in communication with the housing assistance partner. Usually the government it's not the state of Arizona that's cutting a check. It's an organization that's taking government funds and cutting the check. And often you have a tenant that says, hey, my income changed. I'm reevaluating how much this housing partner is going to say, we're now changing the amount that we're going to pay each month. We're changing the amount the attendant's going to pay each month. And so in an eviction action, it might not be crystal clear and straightforward how much the tenant owes. We want to make sure we know from the housing assistance partner how much was this tenant supposed to pay in September, in October, November, because that amount may change. So more work on our end to get that straight.
Makes sense. You mentioned earlier, too, that there was obviously a brief moratorium on evictions. Nothing was going through the courts, so pretty slow there for a while. What are you seeing now in terms of caseload?
Sure. I think there was a recent article in Arizona Central that said eviction filings have reached their pre-pandemic levels, and they've exceeded them. Usually I think we've got a pretty high level of eviction filings happening now. I think it's mostly a function of the economy. I think it's mostly a function of rents have increased somewhat in the past few months. And so you do have folks that are not able to pay the rent. I think sometimes when you read these articles about, landlords are filing more eviction actions, I think the tone is, hey, kind of accusing a landlord of taking advantage or being greedy, but it's, hey, we have tenants that for many different reasons are not able to pay the rent, and so landlords are filing. One thing that's also sometimes hidden in those articles is it's just eviction filings, right? Mm-hmm. And so there are plenty of times that you might file an eviction action and then have the tenant come up with a rent, right? So it's not for every eviction. Okay, it was 7,500 eviction filings last month in Maricopa County. There were not 7,500 families out on the street, right? They were tight, getting close to being behind on rent, caught up, and life goes on.
Yeah, it's typically we see too. Like sometimes they'll be late, but oftentimes they're usually paying before it actually gets to a court date. So
yeah.
So most of the backlog is cleared out at this point. It sounds like you're not like you're saying. A lot of these articles are spinning it like evictions are out of control, but it doesn't seem like that's really what you're seeing. Like it seems pretty relative to the population growth in the valley. And
sure, that's exactly right. Yes, when you're talking about more, if you're looking at just the flat number of eviction actions, and they've increased. There are more people living here than lived here in previous years. Yeah, you've got some population growth going on. And I think that anything that we might say about was there a backlog, I think even during COVID, you had folks either getting rental assistance and getting caught up on rent, or we eventually started processing eviction actions in certain circumstances, right? Even during the moratorium, there were still eviction actions that we processed if the tenant wasn't actively working to get rental assistance, if they weren't actively paying the portion of the rent that they could pay. So I think any alleged backlog either didn't exist or it's been cleared out, and we're just kind of at a baseline level of eviction actions that we might otherwise see.
Yeah. Have you seen any recent law changes that landlords should be aware of?
So I wouldn't say a change in the actual law in the Landlord-Tenant Act, but there are always changes in the way that law gets applied and gets worked through the courts. And that's another reason why you should subscribe to any kind of, we do at Zona Law Group, we do have either a release or newsletter, updates on the status of the law. A couple things to look out for, and that's that 3 cities in Arizona have passed source of income as a protected class. Meaning, we were just talking about Section 8. In 3 cities, in Phoenix, Tucson, and Tempe, a landlord cannot say, I'm not going to rent to you if you're getting government assistance, right? You're a Section 8 tenant, please don't apply. That would violate the Fair Housing Act. So that's a recent change, and you'll see city by city, within the past few months, those cities have made those changes, and others are talking about it, right? It's just going to happen city by city. There may be some push to make that a statewide, protected class source of income, but we'll see. We'll see what happens.
We talk to a lot of self-managing landlords that don't even know what fair housing is. So can you give a quick briefing on what fair housing is?
Yeah, you bet. I mean, fair housing just says that you're not allowed to discriminate against certain protected classes when it comes to renting a property, making a property available to rent, or selling a property to someone. Many of the protected categories are crystal clear. We understand we're not going to discriminate based on race when we're renting to tenants, right? That crystal clear. We all understand that. We get that. We're not going to discriminate based on family status, age, national origin, sex, and sexual orientation. Now is even included there too. Some of the areas where we see questions are we're not going to discriminate against someone with a disability. We're not going to refuse to make a reasonable accommodation for someone with a disability. And that often rears its head when we're talking about pets versus assistive animals versus emotional support animals, right? So there's certain requirements to make sure we comply with fair housing rules to say, hey, does a tenant have a disability? Are they showing a connection between this disability and a proposed accommodation, right? The lease says no pets, but I have a doctor's note that says I need this dog. Is that an accommodation that we can make? Is that a reasonable accommodation? So, and all of that comes under the umbrella of fair housing, right? Are we making any discriminations against people based on any of those protected classes? And in the case of a disability, what accommodations are we making?
So you mentioned disabilities, assistive animals, service animals. Like, what do you see the biggest mistakes that landlords are making when it comes to fair housing then?
I would say that, if you want to couch it in terms of mistakes, the biggest mistake is to not train staff on what to say at each stage of the process, right? If they're screening potential new applicants, right? One mistake that I see companies make is just to say, if you have arrests in your criminal history, don't bother applying, right? Usually, if you want to give just a one sentence advice on fair housing in terms of applications, just say everyone is invited to apply, right? Review all the applications, encourage applications to come in. Then you can evaluate, make those decisions, make sure you don't have any, criteria that are going to be, violating any of these protected classes. You see landlords making mistakes about assistive animals and things by maybe being overly aggressive in enforcing a no pets type of rule. Even when a tenant follows the procedure and says, I have this disability, it may not be apparent, but here's my disability. Here's a note from a licensed professional that says, I need this support animal. If the landlord then at that point says, still, no, I don't care, you can't have the pet, or you need to pay additional pet rent, or you need to pay something else, that's probably a fair housing violation, and they're subjecting themselves to a complaint.
Do you represent landlords in fair housing complaints?
Sure. Yeah, we've got a few of those all the time. Yeah. Sometimes you get one of those and you say, hey, landlord, you might have dropped the ball on this one. Let's talk about resolution, how to fix this. Let's make the accommodation. Let's fix this. Many times you see those from folks who are disenfranchised, folks who are feeling like the landlord did discriminate against them when there's not much there, right? They got rejected for residency for perfectly legitimate reasons, and they're saying, well, it's because of this disability, it's because of this other issue that I have. So on a case-by-case basis, we evaluate those, we help, and we help help the investigating agency see that we complied with the Fair Housing Act.
Yeah.
How can a landlord, if they're renting a property on their own, how can they know what standards are acceptable to enforce for an applicant?
You just want to, HUD publishes guidance, right? You can look and find the guidance. You can call an attorney. You can seek advice, seek some training on fair housing. If a landlord's on his own, that's one thing. If you're a property management company, you want to make sure that there's training that happens on all the ins and outs of fair housing. But sure, a landlord on his own, if he's worried about fair housing compliance, should just seek some education on it. There are websites, there are resources, and like I said, HUD publishes some guidance on that.
Yeah. Another big point of contention in the landlord-tenant relationship is security deposits. So what should landlords know about security deposits?
Yeah, I think a landlord should know that there are statutes that spell out specifically what the obligations of the landlord are upon the termination of the lease. I think the number one, if I see a civil complaint, right, if somebody sues a landlord, if I have to guess what it's for the tenant is alleging they kept my security deposit, they mishandled it, they made deductions that weren't appropriate from the security deposit. Mm-hmm. So again, there are sections of the statute that deal with providing an accounting. The statute says, for whatever reason, it says 14 business days, which isn't really a timeline that you'd expect. 14 days, you think 2 weeks, but it's 14 business days. The landlord has to provide an accounting of the security deposit. It's okay if the landlord has reasons for keeping all the deposit based on deductions that the landlord needs to make for not for wear and tear items, but for damage that the tenant causes to the property or for unpaid amounts, rents that the tenant owes, things like that. But the landlord has to provide that accounting within those 14 business days. There are penalties under the law for not doing so, and often that's a hot issue for tenants, right? The landlord stole my security deposit, right? Even if they're wrong, tenants feel strongly about, I want my day in court about getting my security deposit back.
Yeah. A lot of times landlords will push back with us where they had maybe 10-year-old carpet in a home and it was ruined when the tenant moved out. Let's say the tenant was in there for 2 years and they want to charge them the full cost of the replacement of the carpet. Why is that the correct way to do that?
Right. I think, no, it's not. What you want to look for in making deductions from the security deposit is items of damage that the tenants caused, right? And the statute specifically says we're accepting ordinary wear and tear, right? So you got a carpet that maybe has a life of 5 years, 7 years. Mm-hmm. You've had it for longer than that. You need to replace it anyway. We're not going to charge that to the tenant, right? You need to repaint every so often, right? The landlord can't put that on the tenant's dime unless you find items of damage, right? Tenants sometimes put big holes in the wall, sometimes mess up the walls. That is fine. Those things you can deduct. Not hey, it's just time for a new coat on the property, right, inside.
And if a tenant doesn't agree with the charges that are being levied against them, what resources do they have to fight back?
Yeah. So the statute says that the tenant can object to the accounting, and that usually just takes the form of an email, a phone call, things like that. But the way it normally comes across my desk is the tenant files usually a civil action. Sometimes it's in small claims, sometimes it's in the justice courts. Sometimes tenants are suing their landlords in superior court, claiming not only do you owe me my deposit back, but you owe me $20,000 for my aggravation and my pain and suffering and things. Though that extra little claim in there, we can usually get that thrown out. But we have to look at, hey, landlord, what accounting did you do? What did you send out? What deductions did you make? Do we stand by all those deductions? Landlord, do we have? Essentially, we're in a position where we want to demonstrate to the court that here was the condition of the carpet, the walls, the what have you before, and here's the condition after. Sometimes we don't have those move-in pictures. Mm-hmm. Sometimes we don't have move-out pictures, right? And so we say, hey, look, the tenant is trying to say that we made this deduction in bad faith, or we made a deduction that should not have happened. What can we prove, right? And so, so the remedy for that is let's take those pictures on move in, let's take those pictures on move out, let's keep everything nice and neat, let's document the changes in the property, and let's support each one of those deductions that we make with pictures and with an invoice. Hey,
Right.
we hired somebody, here's the work they did, here's what we paid. So yes, we're charging it to the tenant.
Yeah.
Yeah, because you actually have to make the repair, right? Just because the damage is done. If you don't actually make the repair, then you can't charge him for it, right?
Sure, that's right.
If you are a landlord and you have some wrongfully withheld charges, like what are the damages that you're responsible for that the tenant's entitled to?
Yeah, so I mean, the section of the statute on deposits says the tenant can seek the amount that's wrongfully withheld plus twice that amount. So many judges interpret that to mean there's 3 times damages for a tenant that, for a landlord that wrongfully withholds a security deposit. So the tenant does have a nice remedy there. Say, hey, I'm getting the deposit back, and I'm getting a total of 3 times the deposit back.
It's a good reason not to take advantage.
Right?
Do it in good faith.
Yeah, play it straight, right? And the other thing I just want to point out, sometimes that's an area of contention between a property manager and a landlord, right? Sometimes the property manager is the one that's examining the property, taking the pictures, and the landlord might say, no, I want to charge, like you mentioned, I want to charge this, that, and that to the tenant. As a good property manager might just make that caution, right? Say, hey, look, unless we can support these things, we're subjecting both of ourselves to a lawsuit here. Landlord's ultimately going to be the one on the hook, but property managers are often named in a lawsuit, and they still need to hire attorneys to defend themselves to get the case dismissed. So, good advice to landlords is let's document, let's support, let's only make those appropriate deductions to the deposit.
You mentioned a lot of helpful statutes throughout this conversation that residents and landlords should be referencing. Like, where do these statutes come from? What's the source of truth for landlord-tenant law?
Yeah, you can find a copy of the Arizona Residential Landlord-Tenant Act online. You can go to the Arizona Department of Housing website, or you can just literally Google search Arizona Landlord-Tenant Act. I find myself doing that too.
Yeah.
I mean, I have it bookmarked, but I also just
Same.
Google
I have it bookmarked.
Landlord-Tenant Act, just punch it in.
Yeah.
And when we reference any of these statutes, you can literally just type, if you have a statute number in your head that somebody said, hey, look up this statute, just type that into a search bar, and all of the statutes you can pull up online on the Arizona Legislative Office website.
It's so helpful for us. Like, I try to train our staff. If they come in asking us a question, we pull it up right away. Okay, well, let's see what the statute says. Let's make sure we know what we're talking about here.
Right, absolutely. You're 100% right. It's a great baseline reference and answer point. Sometimes you don't find all the answers in the statute, and maybe you need to call a professional for advice, but you're absolutely right. Many of these answers are going to be found right in the black and white letter of the law.
It's been an amazing conversation, Spencer. I feel like we've really learned a lot. It's been very informative for us. Appreciate you taking the time to talk to us today.
Appreciate you guys. Thanks so much.
If folks want to get in touch with you, how can they reach you?
So sure, please give me a call. You can reach, my phone number is 480-949-1400. You can shoot me an email. I'm just Spencer, my first name, SPENCER @zona.law, ZONA.LAW.
Awesome.
Calls or emails. Thanks, guys.
Thanks
Thank
so much
you.
for your time today.
You bet. Thanks.